something else. So, Madam Clerk, let's put the instructions up. We start with 100. That's a standard instruction. Any issue with 100?
None from the state.
Okay, again, I'll take silence as acquiescence.
Okay, fair enough.
Let's go on to 110 then. I moved 110 up before the substantive instructions based on the first draft that went out. Madam Clerk, could we just make instruction 110 single space to make it consistent? Okay, she'll fix the formatting a little bit, but substantively 110 just mirrors the charging language in the information. I am going to change victim A to Carlos Maldonado. I understand the victim designation in the charging documents, but at this point, Mr. Maldonado has been referred to by name. Any other changes to 110? All right. Instruction 70. I inserted here. I also have the additional line that's not standard in 70. It's about standby counsel being appointed. This is the same instruction that I gave at the beginning of the trial. Any changes to 70 as presented? Okay. What I propose here is to add something to 70 to address the defendant's clothing. I know when the defendant first appeared in jail orange, I gave the instruction to the jury that they are not to consider his change in appearance and his change in clothing. I'm proposing something that's similar to instruction 314, which is to be given when the defendant is wearing a visible restraining device in the presence of jurors. It would simply be that a sentence is added to 70 saying the defendant has appeared in court wearing orange clothing. This must not be considered by you in any way and must not influence your verdict in any manner. What does the state think of that proposal?
No objection, Your Honor.
Mr. Lychwick, what do you think of that proposal?
No objection.
Okay, then we'll add that the defendant has appeared in court wearing orange clothing, period. I think I'll add, you must not infer anything from this. And this must not influence your verdict in any manner.
Period.
This must not influence your verdict in any manner. And also change the spelling. I think you got infer now. I-N-F-E-R. All right, as presented, is that still okay with the state?
Yes.
Mr. Lychwick?
Yes.
Very well. Then instruction 110 is the standard first-degree intentional homicide instruction. It does use the victim's name. Madam Clerk, can you make this left justified, please? So just highlight the instruction and then, no, just the individual text. Nope. Below that, line below that, you see the center is highlighted? Yeah. To the left of the center. Nope, other one. There we go. And then put a paragraph.
You want me to do it to every?
Yep.
Sure.
And then could you, first paragraph, or first line indent on those paragraphs too?
Oh, yeah.
Go back to that last paragraph, please. Okay, and then deciding about intent, we'll fix that. Intent and motive, we'll fix. Any other changes to 110 or requests for any additional instructions from the state?
No, Your Honor.
Mr. Lychwick?
None.
Very well. Then 194 is standard. If we can just put the first line indents, thank you. And then for elements, please separate out 1 and 2. So put 2 on the second line and give it one more space in between there.
Sure.
Thank you. Other than that, that instruction is standard. Any changes? Okay. 140 is a standard instruction. Madam Clerk, if you could just put extra spaces between the text and the heading. There you go, just like that. .145 is standard. 103 is standard. Can we break those paragraphs up, please? 162 we don't need. I don't believe there have been any stipulated facts.
I agree, Your Honor.
Okay. We'll take 162 out. 165 can be removed. There are no judicially noticed facts. 170 will remain in. Circumstantial evidence, we'll just take out the all caps language and also break those paragraphs up. Is the state requesting 172?
Yes, Your Honor.
Flight, escape, and concealment. Mr. Lychwick, any objection to 172?
Would you please go over that again?
Sure. 172, a flight, escape, and concealment is a supplemental instruction to the circumstantial evidence instruction of 170. What it says, or how it would read, is that evidence has been presented relating to the defendant's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. The state is requesting that. I'll hear an objection if you have one.
So the state wants this in?
Yes.
I object.
Okay. Noting your objection, I am going to give 172 primarily because one of the crimes is hiding a corpse, which itself is conduct after the alleged offense was committed. There's also other evidence that I believe would be relevant to having instruction 172 given. So we'll use the after the alleged crime was committed language. And unless the state wants the second bracketed language as well, Attorney Tombasco?
No.
Okay.
That's fine, Your Honor.
175, is there a request from the state for 175 motive?
Yes, Your Honor. I apologize for interrupting. Yes.
That's fine. Mr. Lychwick, do you want 175 or do you have an objection to 175? That is the instruction dealing with motive and that it is not, I'm sorry?
No objection.
Okay, then we'll include 175. I think it's appropriate given the charge of first-degree intentional homicide and the mention of motive not being required and different from intent in the instruction itself. So we'll take out that, those brackets, we'll leave that language in. And then we'll leave that second paragraph as is. All right. 180 deals with statements of the defendant. The state has introduced video statements, so the court will give 180, and we'll use the plural. We do not need the optional statements about the lack of audio or visual recording because the only statements the state introduced were the recorded statements, I believe. Is that correct, Attorney Tombasco?
Yes, that is correct, Your Honor.
Okay. So we'll take that out and then continue with the final paragraph of that instruction. Instruction 270, I don't believe we need. We can take that out. 157 will stay. I will modify 157 to say, right, remarks of the parties or parties. And then I'll say remarks of the parties are not evidence. Any objection to that change, Attorney Tombasco?
No, agreed, Your Honor. Thank you.
Mr. Lychwick?
None, thank you.
154 is summary. The state did introduce that timeline, which would be a summary. So based upon that alone, the court will allow 154 to be read. 155 is standard for exhibits. 148, we did have objections and evidence received. We'll change objections of counsel to objections of parties. Yes, thank you. And then in the second paragraph, to by allowing testimony or other evidence to be received over the objection of parties, of the parties. 147 is standard for improper questions. The court did not allow some questions to be answered, so that will stay in. 150, I don't know that we had stricken testimony, but we had some stricken comments.
Mm-hmm.
Is
I
there
would
a
agree.
request from the state for 150 to stay in?
Yes, I would. I don't know if we want to modify it to stricken statements rather than testimony, but
I'd
somehow.
leave it as is, but Mr. Lychwick, do you have any input on 150?
I have no objections.
Okay, I'll leave 150 as is. 190, weight of evidence is standard. 195, juror knowledge is standard. 300, credibility of witnesses is standard. Could we just break those paragraphs up a little bit for ease of readability? Mr. Lychwick, at this point, and I am not asking you for your final answer yet. I have not taken your waiver colloquy on your right to testify, but are you still anticipating that you will not testify?
Yes, I am, Your Honor.
Okay, then for this credibility instruction, we will for now take out the paragraph to be given only when the defendant testifies. If, Mr. Lychwick, you change your mind about that, we can go back and modify this instruction. Then 315, Mr. Lychwick, if you do not testify, are you wanting 315 in there? It is an instruction to the jury that informs them of your constitutional right not to testify and that they must not consider your decision not to testify against you.
I want that in there, please.
Okay, then the court will give 315. We'll just break those two sentences up. 141, identification of the defendant.
Judge,
Attorney
I think,
Tombasco?
yes, thank you, Judge. I think I think it should be removed now. The only area where it might have been an issue was on the trail cameras, but I think as Mr. Lychwick has acknowledged yesterday, he said it was him, so I don't think that there is an issue regarding identification. I ask that it be removed.
Well, his statements that it was him are not evidence, and those would be regarding the statements of the parties that the court has instructed the jury not to consider. But still, I'm inclined to agree with the state. I think this instruction is more appropriate when there is an eyewitness to the crime who identifies the defendant as the one who committed the crime. Here, the only real question about identification was identifying the defendant on surveillance cameras and the trail cameras, which doesn't really get to the spirit of 141, I don't think. Mr. Lychwick, do you want instruction 141 to be given?
I want it removed.
Okay, then we'll remove 141. I don't think it's necessary in this case. Instruction 200, we have had testimony that could be considered expert testimony, so we'll leave 200 in. We'll just remove the word expert from that. And we can take out the optional paragraph at the end about conflicting expert testimony. We didn't have any of that. 201, opinion of a lay witness. Again, we'll take out non-expert in the title of that, but certain witnesses have been given the opportunity to offer an opinion based upon their experience, so my inclination is to leave 201 in. I don't know that we need to identify the specific witnesses who are allowed to give opinions. We could have it read, ordinarily a witness may testify only about facts. However, in this case, witnesses were allowed to give opinions based on their experience in determining the weight you give to this opinion. You should consider the witness's opportunity to observe, et cetera, et cetera. That way, we're not highlighting any particular witness, but just acknowledging that certain witnesses have been able to give opinions. Attorney Tombasco, any thoughts on 201 as modified?
No, Your Honor, I agree with the court's thought process.
Mr. Lychwick, any opinion on 201 as modified?
Not at this time, Your Honor.
Okay, then we'll give it as written now. We did have hypotheticals, so the court will give 205, and we'll just remove the word expert. 320, I don't know that we had prior inconsistent statements, so we can remove 320. Attorney Tombasco?
I would intend to agree. The only thing I'm a little bit hesitant is if he testifies, it might become an issue, but at this point, I would agree.
Sure. If Mr. Lychwick testifies and that becomes an issue, we can add it. Otherwise, 320 will come out. 325 can be removed. We do not have any witness with prior conviction. 327 similarly can be removed. 340, credibility of child witness, can be removed. 160 is standard. We'll change that to parties. Thank you. And then 460 is standard. We can change counsel to parties in that instruction as well. Let me just put the parties in both of those changes just to make it read a little better. And then we'll use the plural of offenses. And then 480. So we'll have 2 verdicts on each count. The first verdict will be guilty of first-degree intentional homicide as charged in count 1. Second will be not guilty of first-degree intentional homicide as charged in count 1. Then put a space in between. There you go. Thank you. Can you also first line indent those?
You want me to do it? No.
Yes, please. Thank you. Then similarly, we have guilty of hiding a corpse and not guilty of hiding a corpse as charged in count 2. Otherwise, that instruction is pretty standard, and then our verdict forms will mirror that language. Then 515 is standard instruction.
Excuse me, Your Honor.
Yes, sir.
Could I have 480 reworded for reversing this to one reading, we the jury find the defendant, myself, not guilty, before guilty is placed in the text?
Any objection from the state?
That's fine, Your Honor.
Okay, the court will make that change. And then, Mr. Lychwick, what I will do is when the physical verdict forms are presented to the jury, I'll have not guilty on top and then guilty on the bottom.
Thank you very much, Your Honor. Thank you to prosecution.
So 515 is standard then, and then we have the closing instructions, which we will handle when the time comes. My practice for polling the jury is if the verdict is an acquittal on all counts, I'll do a collective polling of the jury, just ask the jurors to raise their hand if that is their verdict. If one or both of the counts result in a guilty verdict, I will individually poll the jurors and have each juror asked individually if that is their verdict. Are there any other changes that the parties are proposing to the jury instructions?
None from the state, Your Honor.
Mr. Lychwick?
None for me, Your Honor.
Then we will print up verdict forms too and have those distributed to the parties before we get to that point, so the parties can review those. So in terms of timing, Attorney Thompson, how much do you think you have left with Detective Stern?
Under an hour.
Okay. And then Mr. Lychwick, you'll have an opportunity to cross-examine Detective Stern. At that point, is the state resting?
Yes.
Okay. We will conclude the testimony of Detective Stern. We will take a break outside the presence of the jury. I'll hear any motions from the defense. I'll talk to you, Mr. Lychwick, about your decision whether or not you want to testify. If you do not testify, you have no other evidence that you're presenting. Is that correct?
I would like to enter into evidence my defense exhibits 1 and 2, the Axon body footage chain of evidence log is for Officer DeBaca and Officer Tyndall for the car stop on the night of 1 December 2024.
So this is just the chain of custody log for that body camera?
Yes, and I believe it's probably already entered into evidence, but I want it entered specifically as my defense exhibit 1 and 2 as proof of to support my allegations of tampering of evidence.
Mr. Lychwick, the only body camera that's been introduced as evidence in this case is the body camera of Detective Stern. And it was only the 2 clips from the interview with you outside your apartment during the execution of the search warrant. There have been no other body cameras introduced into evidence in this case, and the jury has not seen any other body cameras in this case. So the chain of custody doesn't relate to Detective Stern's body camera, correct?
It does not.
Okay. So you are not intending to play the body cameras of those officers, are you?
I could, but I am not able at this time to demonstrate the tampering that was done to it. I don't have the wherewithal to do that at this time. I've been trying to do that over this past 18 months. 8 months when I discovered, through discovery, that the footage was tampered with both digitally, visually, and audially.
What witness are you going to introduce those exhibits in through?
I don't have an expert witness at this time. I wasn't able to come up with one. I'm still searching.
Is the state stipulating to the admission of those exhibits?
No.
Okay. Mr. Lychwick, without an exhibit or without a witness, I don't know how you're going to get those exhibits in. I understand that you've expressed a desire to have an expert witness for many months now. And this case has been pending for a long time. I've discussed with you your right to get an expert and your right to prepare a defense. But the trial was this week, and if you are without an expert witness for that, there's not much you're going to be able to do to get that evidence in and get the allegations in that I think you want to get in. What I will let you do, Mr. Lychwick, is this. When it comes time for, or when we're done with the state's case, when we take that break outside the presence of the jury, what I will allow you to do is provide an offer of proof to the court, and that would become part of the court record. So what it is essentially the testimony that you believe you would have been able to get in had you had an expert witness in this case. Okay? I'll allow you to make that record. I'll take your exhibits as part of your offer of proof, but that would be just for the court record. It's not something that the jury would hear because you don't have the witness to testify about that. So for purposes of appeal, if you want to appeal this case, if you are convicted, your offer of proof would at least be part of the record then.
At this point, it sounds somewhat fair, Your Honor.
Okay. Well, we'll take that up again when we take the break at this close of the case. The close of the state's case.
All right, thank you, Your Honor.
Mr. Lychwick, then if you do not testify and if you do not have any evidence, would you like to formally rest in front of the jury where you say the defense rests, or would you like me to do that on your behalf?
I'll take care of it, Your Honor.
Okay. Then the only other thing I want to go over with the parties here before we bring the jury in are the exhibits. Again, I want to update what my record is of the exhibits and confer with the parties. Attorney Thompson, do you anticipate having more exhibits?
Yes.
Okay, that's fine. We'll do a final count later. Right now, what I have is in and published exhibits 1 through 50, and that includes 1A, 1B, 1C, 28A, 34A, 41A. I'm going to do these in batches of 50 because that's how I have my list organized. Is that correct from the state?
Yes.
And Mr. Lychwick?
I'm not exactly sure, I'm sorry, where we are with what we're discussing here.
Sure, we're discussing the exhibits. I just want to summarize the exhibits that have already been received and published to the jury. So my records show that 1 through 50 plus all of the sub-exhibits with diagrams and markings, 1 through 50 have all been received and published to the jury.
And I believe I objected to all those already anyway.
I think you have, and they have been introduced over your objections. So your objections noted.
Right.
My clerk informed me that we had a problem with 1B. That was the aerial photograph with the markings of Miss Nelson. The system indicated that 1B was captured with Ms. Nelson's markings, and my clerk got the notification that it was captured, but it, for whatever reason, did not save. So unfortunately, we do not have 1B saved in evidence.
Now, is 1B the aerial photograph of the top of the hill or at the point where the decedent's body was discovered?
Exhibit 1 was the Google map of the apartment complex and the surrounding area. 1B was the same Google map with Nichelle Nelson's markings for, I think she placed 2 markings on there. One was a line, one was a small circle. We lost the capture of her markings on that exhibit.
So this is separate from the exhibit where I asked the witness to put what was really a dot over the spot where the decedent's body was discovered, proving that it was in that location. This is not having to do with that exhibit, right?
Judge, would it be helpful if I pulled up Exhibit 1?
Sure.
That would help, thank you.
So, Mr. Lychwick, this is Exhibit 1.
Right.
And then Exhibit 1B was this same exhibit, but with Ms. Nelson's markings for, let me review my notes here. I'll tell you. Yes, this was on cross-examination when you had Ms. Nelson mark where the body was, and I believe where she approached.
That is a very important exhibit to my case, Your Honor. I think we should maybe ask her to place her markings there again for the jury to see, to make sure that there is no doubt.
Well, I understand that that was the focus of your cross-examination with Ms. Nelson. It was done while the exhibit was up on the screen. So the jury did see that. The jury saw her making those markings, and it was up on the screen for a little time. So the jury has seen it. It would just be a matter of if the jury requests to view Exhibit 1B again, they would not have that available for their viewing.
Your Honor, I think it's very important that somehow that marking, at least where the decedent's body was discovered, be placed on there again for them in the green highlight marker.
Attorney Thompson?
I think it's pretty clear from all of the other scene exhibits where Mr. Maldonado's body was located. So I agree with the court. The jury, just like they have to rely on their collective memories about individual witnesses' testimony because they're not getting transcripts, this would be a similar scenario where they have to rely on their collective memory about the specific markings on 1B, but I think there are other exhibits in which we could get that information from.
Mr. Lychwick, I tend to agree with the state. I don't think there's much dispute in where this body was. We've seen multiple photographs of the actual location of the body. So the witness's drawing of where she remembers the body is less probative than all of the other exhibits that show exactly where the body was located. Furthermore, as I said, the jury already saw Ms. Nelson place those markings on Exhibit 1, and that was done while the exhibit was up on the screen. So they can rely on their memory of where she made the dot on the exhibit. So unfortunately, it's just not available. It's a glitch in the system. All of the other markings in this case have been captured. We just lost 1B for some reason, and I can't explain why that happened.
Your Honor, that's not satisfactory to me, the defense. I must insist that that marking be placed where she had placed it.
All right. Well, Mr. Lychwick, I note your objection and I note your frustration with it, but at this point, I don't think there's anything we can do to recreate that. So we will move on with the exhibits. For the next batch, 51 through 100, I have all of those received into evidence, and they have all been, that also includes 59A, 80A, 81A, and 87A. All of those exhibits have been published to the jury except for 58, which is the Wiedenhoft CV, 75, which was Ms. Gummon's CV, and 76, which was Ms. Gummon's report. Does the state agree?
Yes.
Mr. Lychwick, do you agree on that?
I don't really understand what I'm agreeing to again at this point.
I'm just recapping which exhibits have been received and which exhibits have been used with the jury.
Have I objected to those particular exhibits already?
Most likely you objected to some of them. A number of them were received while you were sitting mute and not participating. So I don't remember which ones were received over your objection, but your objection, if you made them...
They've been covered already, Your Honor.
Yeah, it would be covered already and it would be part of the court record.
Well, at this point, I don't think there's much I can say about that then.
For the next batch, 101 through 150, I have 101, and then I have 108 through 143, and 145 through 150. That includes 145A, 146A, and 150A. All of those exhibits have been used with the jury except for 108, 109, 110, 111, 113, 115, 117, 140, 142, 143, and 149. Does the state agree?
Yes.
Mr. Lychwick, do you have anything different on that?
I don't really know what these exhibits are. I probably have them in my files here somewhere, but it would take too long to go through them and look at them, and I don't have access to a computer, so I can't just bring them up. I don't know what I'd be agreeing to or disagreeing to.
Okay. Well, if the time comes, the bottom line, Mr. Lychwick, is that it's your responsibility to keep track of the exhibits too. The official court record of what exhibits will be received will be maintained by my clerk. I'm just trying to do a courtesy to the parties to verify that my clerk has the correct information. So that's all. The official record will still be maintained by the clerk. All right, the next batch, 151 through 200, I have all of those exhibits received into evidence except 153 and 154, which were the two boxes of Luger ammunition. There was no 181. Otherwise, everything else is in. And as far as publication to the jury, the ones that have not been published are 151, 151A, 153, 154, 155, 156, 177. That was one of a series of photographs of the L2 vertebrae with Dr. Scheel. The others were used. 177 I did not mark as actually having been used. 179 was not in and not used. I should have specified. I think I forgot about that one. 179 was not in and not used. Otherwise, is that consistent with the state's list?
Can you please repeat what you said regarding 153 and 154, which is the boxes of ammunition? I thought I heard you say they were not admitted.
I have them marked as not admitted, Madam Clerk.
Okay.
I don't have note of either one of those.
Okay.
I know they were referred to. I just don't believe the state has moved those in yet.
Okay.
Mr. Lychwick, is that consistent with your recollection or your memory?
Well, I would definitely object to their being admitted.
Sure, the state hasn't moved yet. I was just asking if the overall list was consistent with your notes or memory. Then the final batch after 201, I have 201 through 212, all admitted and published, and 215 through 219 admitted and published. Is that consistent with the state?
Yes.
Mr. Lychwick?
I wouldn't know what to say at this point with that, Your Honor.
Understand. Very well. Anything else we need to take up before we bring the jury back?
Yes. I have a question for the court. Exhibit 213, which is one I intend to use with Detective Stern, that is a recorded video call of the defendant in the Waukesha County Jail with another individual. Now, he has told the jury, and the jury can see at least that he is in orange, and in this video he will be in orange. It shows him coming out of his cell to start this conversation. So how I intended to try to mitigate is to ask Detective Stern, did you watch a recorded video call between Mr. Lychwick and another individual on June 10th of 2025 and not reference jail? I'm playing a portion of it where you do not see him coming out of the cell. It's towards the end of the conversation. I don't know if the court has any other way in which you want me to continue or additionally try to mitigate, but it's a video call, and that was the best that I could come up with to not draw attention to that fact and instead focus on the words of Mr. Lychwick.
Has that video been provided to the defense?
Yes.
Is it possible to play the video without, or play the file without the video and have it just audio?
That would be fine. When I publish to the jury and when I play it, we can just take it off of the screen so that maybe we can see it here at council table. But that...
The audio would still be going? That would be the easiest way to do that, and then it can be characterized as a call, or you can characterize it as a video call, however you want to, just not reference jail, and then the audio will be played to the jury.
Okay, I can do that. Thank you.
Mr. Lychwick, does that proposal sound appropriate?
It does, but I would like to object. I haven't had a chance to object to the introduction of that piece of material into the prosecution's evidence against me, as that video call was a conversation between myself and, at the time, my power of attorney, Alan D. Fisher. He was my power of attorney. It was a private call, Your Honor. Detective Stern had no right to interfere with that, to snoop into that call.
Attorney Thompson, who is the call with?
It is with Mr. Fisher, but I'm not aware of any kind of power of attorney.
I have paperwork to that effect, Your Honor. I have the draft copy. I don't have access to a Xerox machine here, so I have copies of the draft copy of his contract being my power of attorney. And Mr. Fisher has returned that, upon expiration of it, he has returned it, and it is sitting in my mail being held for me at the Waukesha Post Office at 600 Broadway.
What do you have in your possession, a draft contract?
The draft of the actual contract with Mr. Fisher being my power of attorney.
When did you enter into that contractual relationship with him?
I believe it was the later part of the mid portion of the year 2025, probably around March of 2025. And he remained my power of attorney, I think, until October of that year when it expired.
Was the nature of the discussion in this conversation legal matters or anything related
Yes, it was.
to power? Hang on. Or anything related to representation or anything within the purview of a power of attorney, Attorney Thompson?
Well, I'm not sure what the nature of this power of attorney is, whether it's medical or financial, but the nature of this conversation is that this individual confronts Mr. Lychwick with what the evidence says was recovered from his vehicle during the search, and then Mr. Lychwick responds, he doesn't know anything about that gun. He's never seen that gun before. It's inaccurate that it was a Luger that was used to murder Mr. Maldonado. And he also is asked about the items he removed from his storage unit to place in his trunk that where we eventually found the firearm. And Mr. Lychwick acknowledges that those are his war bags and that he lists items that we actually did recover in those bags. So it shows his knowledge of the bags. And what I would argue in closing is that conveniently, that's the one item in the bags that he claims to have no knowledge about, but everything else in those bags he knows about. So it's relevant specifically to this case, but they're not talking about legal theory in this section. If the court would like to have an in-camera review, I can certainly do that. I have the timestamps, but this is specifically related to his acknowledgement of his war bags and the firearm recovered.
Mr. Lychwick, what was the nature of your relationship with this individual in terms of power of attorney? Was this for health care, financial, or what?
It was for everything, Your Honor. He was looking after my interests. He had my life in his hands. I had no one else outside helping me at the time. He was my de facto legal presence outside. He was trying to help me legally as well, find legal representation. He had right to know about this case. He was curious as to, he had looked up, with my permission, the criminal complaint and studied it over, and he was wondering what was in these bags that they were writing up, having taken out of the trunk of my car. And I unashamedly apprised my power of attorney what was in there. And it was, again, I stressed this was a private call between me and my power of attorney.
Well, Mr. Lychwick, what did the contract say? Was it a financial power of attorney? Was it a healthcare power of attorney?
It didn't specify. It specifies he is my power of attorney. This is a testimonial that you are my power of attorney. I don't believe I have it with me. It's in another file, but I can bring it for the court. I can access it for the court.
Is it in your materials in your cell?
It's in my materials in my cell. I just can't. It's one of my files in there.
Attorney Galaviz, do you have any knowledge of the power of attorney and what it would encompass?
No, sir. I've communicated with Mr. Fisher, and he represented that he was Mr. Lychwick's power of attorney.
How long is the video?
The clip itself, I would be playing from 24 minutes and 37 seconds to 26 minutes and 6 seconds.
So it's a 2-minute or so video clip?
Yes.
And this is for the purpose of tying the defendant to the items that were recovered in his trunk in his car that he was driving at the time the items were recovered. after police watched him remove those items from the storage unit that lists to the defendant, and the defendant contracted to rent.
Yes.
All right, I'll have to take a look at it. I'm going to take a look at privilege as well. Let me do that now. You have it on a thumb drive?
I do, yes.
What exhibit would this be?
This would be 181. Oh, no, I'm sorry, 213.
While the court is reviewing that, Mr. Lychwick, would you be able to find the contract that you have in your materials?
If I could have access to my other files, I'm sure I could locate it, Your Honor.
They're in your cell?
You know what? I just might have it with me because this file contains my attorney.
All right, why don't you take a look at your
My
materials?
attorney-related business. It might, but then I might have filed it with. Let me check here, Your Honor, please. And the state, let me check. I might have it. I just might have it here. This is my attorney's sub-file. But I may have.
Attorney Thompson, do you have the thumb drive? All right, we'll take a short break. I'm going to review this. What was the timestamp again, Attorney Thompson?
24 minutes and 37 seconds through 26 minutes and 6 seconds.
And is it labeled as Exhibit 213 on here?
Yes, it is.
Okay, Mr. Lychwick, while I'm reviewing this, you can go through your documents. We'll stand in recess. Quick matter, appearances are the same. The court had an opportunity to review the proposed Exhibit 213 on the thumb drive from 2437 timestamp to 2606. The court also notes that Mr. Lychwick was able to produce a 4-page document, both sides, that my clerk has copied and will be made part of the court file. A copy has been provided to the state as well. What the court reviewed was that clip as well as some of the context surrounding that clip, because I wanted to get a sense of how the conversation with Mr. Lychwick and the other individuals started and what the parameters of their conversation was about. The court does note that at a couple of times before the proposed Exhibit 213, particularly at 8 minutes and 55 seconds of the video, Mr. Lychwick makes reference to trying to pay this other individual and pay his expenses. And it's clear that the other individual had already looked into Mr. Lychwick's car situation. The individual was at the defendant's apartment, and that the individual had access to Mr. Lychwick's mail and bills and knew Mr. Lychwick's utility balance and other things like that. I briefly reviewed the contract, which is titled a draft power of attorney. What the court finds important here are the differences between an attorney-client relationship and a power of attorney. The attorney-client privilege is discussed in Chapter 905 of the Wisconsin statutes, and under 905.03, lawyer-client privilege applies to the relationship between a client, who in this case is a person, and a lawyer, who is a person authorized or reasonably believed by the client to be authorized to practice law in any state or nation. That is different from Chapter 244, which covers powers of attorney. Under Chapter 244, specifically 244.02 sub 9, a power of attorney is a writing or other record that grants authority to an agent to act in the place of the principal, whether or not the term power of attorney is used. Essentially, what this document is, and what Mr. Lychwick says is his relationship with this individual, is a power of attorney, which grants this other individual the power to act in place of Mr. Lychwick. That is different than acting as a lawyer that would establish a lawyer-client privilege. In that case, a lawyer is someone who's authorized to practice law. There's no indication that this other person is authorized to practice law. And throughout the conversation with this individual, Mr. Lychwick makes reference to consulting with his lawyer. So this was during a time when Mr. Lychwick had representation of a criminal defense lawyer to handle this case. Mr. Lychwick had conversations with the other individual about his lawyer. And the portion that the state proposes to be played from 2437 to 2606 is not in furtherance of legal representation. It's not asking the other individual to make certain representations to Mr. Lychwick's attorney. It's not asking this other individual to stand in Mr. Lychwick's place and have a further conversation with an attorney that would trigger an attorney-client privilege. So I don't believe that this conversation implicates a lawyer-client privilege. The power of attorney is much different than what would be considered a lawyer-client relationship. And therefore, for that reason, I will, over the defendant's objection, allow the state to play 213 from 24 minutes, 37 seconds to 26 minutes and 6 seconds. As I said before, we'll play it audio only so that the video does not demonstrate that Mr. Lychwick is in custody. If the video were played, it's clear that Mr. Lychwick is in jail. All right, the documents that Mr. Lychwick submitted will be made a part of the record, Mr. Lychwick, so that preserves your objection for appeal. Anything else then from the state before we bring the jury in?
I would just note that when you, assuming that I have Mr. Fisher's name spelled correctly as Allenfisher, he is not a licensed attorney, at least not in the state of Wisconsin.
Okay, thank you. Mr. Lychwick, anything else before we bring the jury in?
I can't think of anything.